What are the tax implications if I want to gift a property to somebody, but I potentially want to keep living there? Hi, I'm Kimberly Shapcott, qualified chartered accountant, property investor and entrepreneur. Let's sit down and have a chat. Have you and your parents been talking and considering moving a property into your name, but it's previously owned by your parents, and thinking this is a great way to save inheritance tax in the future? Well, we need to have a bit of a chat about something called gifts with reservations, and have a chat about what this is, what the impact is, and how you need to have a bit of awareness for inheritance tax planning to make sure that you're not falling foul of something and finding out you're going to be paying some inheritance tax when you maybe didn't realise you were going to. So, what is the concept of gifts with reservation? Well, many moons ago, there was this consideration that some people were trying to evade or avoid inheritance tax by moving things into other people's names, but still enjoying the benefits of using those assets. So if we think about that family home, and mum and dad are living in that family home, but they're thinking of doing some inheritance tax planning to hopefully minimise any tax that may be due. And one of those options is, let's move the family house into the children's name. So let's have a son and a daughter to keep our 2.4 children family going. And son and daughter go, yeah, that's fine, let's move it into our names, and then it's not in your name. However, mum and dad are still planning on living in their house, that house that is now owned by their son and daughter, but the parents are still living there. Now, the reason that this falls foul is they're still benefiting from that property. They've not arguably given the full gift. They've given a gift, but it's like, but we're going to keep hold of it really in the true essence of what has happened. So this is why the gifts with reservation rules were introduced. The concept being that when that gift of that property is given to the children, it's known as a potentially exempt transfer, or a PET for short. And that PET, as long as their parents lived for 7 years, became untaxable to inheritance tax in line with the 7-year rule. Check out the video on the 7-year rule on the channel. So now I've got a gift that's given, it's been more than 7 years, but their parents are still living there. So HMRC, the taxman, had a bit of an issue with that. If no additional rules were introduced, then arguably that would be tax-free from an inheritance tax point of view. So these rules were very much introduced to minimise the avoidance of inheritance tax, where people were gifting something but not truly gifting what was being given. So the key points here where it falls within a gift with reservation is something that the deceased has given. It's been given but with a reservation. So for example, with our property, but they're reserving the right to continue living there until they pass. The gift was given on or after March 1986, which I think for most of us, we can definitely say these things are happening now. So that would also fit in. And it wasn't an exempt transfer. The basic premise is that in essence, you may legally transfer the property out of the mum and dad's name into the son and daughter, but when it comes to inheritance tax, if the parents are still living there and that gift has been given but they're still there, in essence, inheritance tax ignores the legal substance and that the property has been transferred and still treats that property as if it's owned by the parents, and the inheritance tax is calculated based on including that property within their estate for inheritance tax purposes. Obviously, as an inheritance planning strategy, this doesn't work. However, there are some different options that you've got available if this option wants to be done, and it wants to be done fully and properly. So what are those options? To stop the gifts with reservation rules kicking in, What you in essence need to do is, if the mum and dad are gifting the property to the children, the son and the daughter, that needs to be a proper gift. So they are actually gifting the property, and now the parents, they may want to stop in the property, but rather than stop there for free, in essence, the property is owned by the son and the daughter. They need to pay rent to their son and daughter for the property that they're now living in, because they don't own the property, so they've got no legal right to live in that property apart from if they set some sort of rental agreement in place, so it is a proper formal rent. Now you might go, oh yeah, that's fine, we'll just charge them a notional rent, and it's not a problem. No, we are talking about a proper market rate rent, so there is no justification that HMRC can actually say, well no, this is just basically still doing gifts with reservation, you're trying to avoid it, but it doesn't work. No, if you are doing this as if your parents, mum and dad, could live there, or they might move out and you got someone else in to rent, it needs to be that market rent, so it is seen as a true proper commercial transaction, and that's what would happen whether the mum and dad are in there or someone else is in there. So that is one way to make it a legitimate transfer, which then means that there is no issues from a kind of inheritance tax position, and the plan has worked with moving the property into the children's name. Obviously, you can't just say there's rent and it doesn't get paid. So it does need to be a physical transaction. It does need to be shown to be happening, because if it's not, then again, it's not a true transaction. Something to watch out for is obviously, as son and daughter are receiving rental income now, they will need to report that rental income to HMRC on a personal tax return. So there is implications on doing this correctly and properly to ensure that the inheritance tax is minimised, but the other side of thing is there will be potentially income tax implications, and obviously mum and dad need to be able to afford to pay that rent, because otherwise what is the point of doing all of these transactions to find that it makes them in a worse position than they were before. The other option is it may be a point where the gift with reservation option disappears at a future point. So if we think mum and dad are going to pass the property to the son and daughter, and maybe they hit a point where actually they can't live in that property anymore. It's got a set of stairs, they're struggling with the stairs, or maybe they need nursing care at that point, and potentially they're looking at transferring their mother and father into a home where they can get the care, the support that they need. Now at that point, the parents are not living in the property. They move out of the property. That property that has already been passed to them, potentially at this point, we have now got no further gift with reservation, because if the parents are no longer living in the property, then that property isn't a benefit, there's no reservation on it, it is now a true gift that the parents have given, and in essence the 7-year rule will start from that point in time. Now this may be at the point where you kind of go, it may be one parent is still living there, or one parent has passed away and it's just left that one is going into a home. There are many, obviously, variations to this, but the key point is the benefit has in essence disappeared, because neither of them is now living in the property, and the property is in the ownership of the children. Now it may be one of the children wants to move into the property. I know many a family that kind of, they swap houses in essence, and the parents move out of their house as it's the bigger house and they want a smaller one, and the family move back in. Now there is a few points to note where gifts with reservation does re-kick in if the family member whose house it was does start living in that house again. For example, they move into, I don't know, a bungalow because that suits them, but then they can't live in that bungalow anymore. They need more support and care, and they actually come and live with the daughter or the son who may be living in that property at that point in time. So they're now again living in the property that was originally their own property. Now the rules very much clearly state that it won't trigger the gifts with reservation if they're stopping for less than a month. If the donor goes and stops at the house, so maybe house sitting, but that's got to be no more than 2 weeks. And if the donor, the person gifting the property, just goes for domestic visits, there's obviously no issues going and seeing your family at their home or stopping for short-term visits. So there is a few things where you just need to watch out for in case there's kind of some house swaps and different people go back to living with each other if there is any care needs. That is just something very much to watch out for and take care. Ultimately, if you're planning on gifting a family home to other family members but still living there, there are definite issues with this approach because of the gifts with reservation rules. If you are thinking of doing this and doing future planning for potentially moving out in the future or paying market rent, then there may be ways to work with the rules to make sure that you're ticking the right boxes and you're not falling into the gifts with reservation rules. However, please ensure that you are aware of them, you know how they are going to impact you, so that if you are thinking of doing something like this, you know what the implications are, so you can make sure you're doing it in the right way for you and your family. Hopefully today you've got an idea of a gift with reservation and how that is going to impact your inheritance tax position. If you have any questions, then please do leave a comment. Please like the video and do subscribe to the channel. And let's make tax less taxing. Let's make tax less taxing.